The government is set to reintroduce the Waqf Amendment Bill 2024 in Parliament today. Now, this bill proposes several changes to the Waqf Act of 1995, the original act which regulates the Waqf properties in India. Now, these are properties permanently dedicated under Islamic law for religious or charitable purposes such as mosques, graveyards, schools, or income generating assets for the Muslim community. The bill has triggered sharp opposition from political parties and Muslim organizations because they argue that the amendments will dilute the Muslim community's control and allow greater government interference. So, first and foremost, let us try to understand what is Waqf and why it is important. Now, Waqf is a system where a person dedicates a property for religious or charitable use in perpetuity. Once declared as Waqf, the property cannot be sold or transferred and must be used for public good. These properties are managed by the State Waqf Board as per the Waqf Act of 1995. The new bill proposes 44 amendments to this act. It was first introduced in Parliament in August 2023 and was later sent to Parliamentary panel. While the panel approved 14 amendments, all opposition members opposed the bill and submitted dissent notes. Now, first and foremost, let us try to understand why the amendment is required to the Waqf Act. Now, opposition leaders like Owaisi, they argue that the amendments weaken the Waqf framework and they erode the Muslim community's right to manage its own religious properties. The government, however, says that the original 1995 Act has gaps and has led to increasing disputes, illegal occupation, and mismanagement of the Waqf land. Another concern is that the Waqf tribunal decisions currently cannot be challenged in courts, and this limits the judicial oversight. The government also argues that the bill will bring transparency through the digital listing of Waqf properties. Also, it reduces litigation and it streamlines the governance. The second point that we need to understand is about the increased government role in property decisions. Now, one of the most debated changes is that the power to decide whether a property is Waqf now goes to the district collector. Until the decision is made, the land will be treated as government property. Please remember, earlier this decision rested or was rested with the Waqf Board and the Waqf Tribunal. Critics say that this shift could delay recognition of genuine Waqf properties and reduce the authority of the Muslim community. The bill also removes the concept of Waqf by use, which means where a property used consistently for religious purposes could be treated as Waqf even without formal documentation like, let's say, the Waqfnama. Critics argue that this could put many old but genuine Waqf properties at risk of being de-recognized. The third one is change in survey mechanism. Now, under the current law, these surveys are conducted by a survey commissioner appointed by the state. The new bill gives the responsibility to the district collector or a deputy collector level officer. The government says this is to speed up the process as surveys in many states like Gujarat have either not started or are severely delayed, such as Gujarat and Uttar Pradesh. The fourth change in the bill is with respect to the Waqf Board composition. Now, the bill allows state government to appoint a non-Muslim CEO and at least two non-Muslim members to the Waqf Board. Critics argue that this undermines the Muslim community's constitutionally protected right to manage religious affairs. The government clarifies that non-Muslim members will not form the majority and says the aim is to bring administrative expertise and promote transparency. A BJP MP has suggested that at least the government official on the board should be someone who deals with the Waqf matters at the senior level. Then the next change is with respect to removing Limitation Act exemption. Now, currently, the work properties are exempt from the Limitation Act 1963. This act prevents land claims after a set period, usually it is 12 years. This allows Waqf boards to recover encroached lands even after decades. The bill proposes to delete this exemption. Critics fear that this will benefit those who have illegally occupied the Waqf land for over 12 years and allow them to legally claim it as their own through adverse possession. Now, let us also try to understand how are the religious properties managed across communities. This controversy also raises broader questions about how religious properties are governed in India. Now, please remember the Hindu temples in many states are directly managed by the state governments through temple boards and the endowments or the endowment departments under the state government. In contrast, the Christian institutions manage their assets through the church trusts, and the Sikh gurudwaras are managed by elected bodies like the, let's say, a trust appointed or elected by the people of that community. These communities largely retain control over their religious properties with only limited government oversight. In the case of Waqf, although the Waqf boards are statutory bodies and receive government oversight, the daily management is meant to remain with the Muslim community. Critics argue that the new bill shifts too much power into government hands beyond what is seen in the management systems of other religious groups. So, all in all, to sum up, the Waqf Amendment Bill 2024 is presented by the government as a reform measure to close legal gaps, stop misuse, and promote transparency. However, many fear it may lead to excessive government interference and weaken the autonomy of the religious trust. If passed without sufficient dialogue, it could set a precedent that affects the delicate balance between state authority and the rights of the community. So the way forward lies in wider consultation with all the stakeholders, the Waqf boards, the religious leaders, the legal experts, the civil society before passing sweeping reforms. Rather than bypassing the community, the focus should be on strengthening systems from within, ensuring accountability without eroding autonomy. That would be truly balanced and inclusive reform, right?